Well, good morning or afternoon, depending on where you are today. Thanks for joining us, and thank you, Trent, for that great intro, and hello to all my friends out there. I've been around in this crazy legal support world of ours for quite a bit. Rode my bike to court to do my first filing almost 38 years ago, and I'm a former court runner, process server, office manager, and small business owner, like I would imagine a lot of you are or have been out there. I remember back in my day, handwritten dockets were part of what I saw. We had pagers with no displays. And for those of you who remember payphones, yeah, it was 10 cents to make a call. Two-way radios came later. For us in the attorney service business, that was awesome. We can actually talk to our runners at the counter or our process servers on location. And I'm sure most of you remember, there might be some youngsters out there who didn't have the privilege of remember those portable mobile phones that were about the size of a car battery? Yeah. Today, here we are talking about electronic filing. That's ServeCon and electronic service, which, can't resist the pun, my apologies, is part of the process. Now, I do want to put that in some context. When we talk about eService with eFiling, we're referring to eNotice or eDelivery. For example, service on opposing counsel, 1011 notices we call them out here in California. We're not necessarily referring to service of primary documents like summons and complaints, although I think one of our panel members may surprise us with a little bit of info about that throughout or later on in the presentation. Well, technology continues to move forward, as all of you know. Fax filing was introduced in California back in 1990. Orange County e-filing started in 2010. Well, that's a 20-year gap out here in California, and in that time and beyond, other states have made some progress. And Jim and Casey can speak to that, perhaps. The federal system, the CMECF, that some folks refer to as PACER, began in 2001 with bankruptcy court, and then in 2002 with district courts. But lately, the speed at which things are happening regarding the e-filing world is exponential. Courts in all states and other countries are realizing they can't continue to do business the same way. And that's having an impact on our business model. Well, the first step in alleviating some of the scariness of all of that, because we understand this could be a scary time for attorney services, first step in alleviating some of that fear is to gain some knowledge. And attending this webinar is a great start. I would also suggest you learn all you can about what's happening in your area and beyond. Take advantage of those relationships that you have with your court people. The second step I would posit to you is looking at opportunities, not just the downside. And you may hear some downside today, but I urge you to look at the opportunities more than the downside. My hope is that today's panel will help you see that and get those creative juices flowing. And of course, I, David, and others are more than willing to answer your questions, whether that be today or in the future, so please do reach out to us anytime. Before we begin, here's the game plan. I'm going to introduce the entire panel, and then each of them will take a few minutes with some specific remarks. There will be some time for some Q&A, we hope, but if not, rest assured we'll get those questions answered any way we can. If you do have a question that you'd like directed to a specific panel member, please do mention that. And we're going to try to keep it fun and lively. I know the subject doesn't necessarily lend itself to that, but we're going to do our best. All right, so the housekeeping is done. Let's meet our distinguished panel. First up on the list is Alan Carlson. Alan is the Court Executive Officer for Superior Court of California, Orange County. OC is one of the largest trial courts in the country, and Alan has over 37 years working in state and local justice systems. He's the former court executive of San Francisco and Monterey Superior, and he has a JD from the Hastings College of Law in San Francisco. His court pioneered what I call true e-filing in California back in 2010, and Alan likes to blow off stress by getting a duck's eye view of the world from his kayak. Say hi, Alan. I think Alan's on mute, but you can see the hand wave.
Good morning.
There he is.
Good morning from California.
All right. Thank you, sir. The next member of our panel is Casey Kennedy, the Director of Information Services for the Texas Office of Court Administration. He and his staff provide IT services to the Supreme Court of Texas, Court of Criminal Appeals, and 14 intermediate appellate courts, and 5 judicial branch agencies. He's the vice chair of the executive board of the Court Information Technology Officers Consortium, and he has a BA in computer science from the University of Texas at Austin. The Longhorns. Casey wants you to know that last year he was the proud first place winner of the Court Technology Geek Off competition at the National Court Technology Conference. Welcome, Casey.
Good afternoon, everybody, and thank you. I am in Austin, Texas, and maybe you can hear my Texas accent. I can't hear it, but you all probably can, and that's okay.
Wait, we have the accent, not you, I thought. Thank you, Casey. Next on the list, I want you to meet Jim McMillan, the Principal Court Technology Consultant for the National Center for State Courts. Jim joined NCSC, as it's called, in 1990. He's a senior faculty member for the Institute for Court Management, and he's provided technical assistance for trial and appellate courts and administrative offices in all 50 states. He's also consulted on projects for the United States Supreme Court, as well as the Arkansas and Massachusetts Supreme Court, and he's worked on various statewide automation projects. And Jim is not just focused on the country, he travels out of the country a lot, and he's provided expertise to courts in Bosnia and Herzegovina, Bahamas, Croatia, Egypt, Russia, and more. I think he's going to bring some interesting insight from a country in Africa, as I recall. And Jim likes to spend 1 week a year providing Race Week support for the All-American Soapbox Derby. Say hello, Jim.
Hello, everyone, from Williamsburg, Virginia.
Thank you, sir. All right, if I can get my screen to advance, I'd be doing well. Next on the list, sorry for the pause, David, that was just for effect, is David Nill, founder, president, and CEO of Rapid Legal, Inc. David, as many of you know, is a longtime member and supporter of the legal support community, about 30 years. He's the former president, ledge chair of CALSPro, and is a recipient of CALSPro's highest honor, the Burt Rosenthal Memorial Award. David is also a former NAPS board member and officer, and he's one of the first attorney services in California to make the leap to e-technology, which is why David is here today, to bring that perspective to you all. David's a poker master, so if you've got money to burn, play poker with David. Welcome, sir.
Good morning, everyone.
And last, but certainly not least, as the cliche goes, I'd like you to meet Snorri Ogata, Chief Information Officer for the Superior Court of California, Los Angeles County. Snorri has over 30 years of IT experience in a variety of industries. He joined the LA court in 2010, January that is, and he's responsible for the court's overall IT efforts, supporting 530 judicial officers, 4,500 employees at 40 different locations. He's the former CIO for the Orange County Superior Court, and it was his team that led that OCE filing effort in 2010. I'm just astounded by those numbers. That is one big court to manage. As of 2000, Snorri was one of only 30 people in the world that were 50% Icelandic and 50% Japanese. And I believe that's probably still the case today, Snorri. Welcome, sir.
Well, hello, everyone from Long Beach, California.
All right, so the intros are done. Thank you all panel members for being here today. And let's turn it over to Alan to kick things off. Sir, the floor is yours.
Okay, thank you, and thanks for the opportunity to talk about what we're doing in Orange County. I'm going to explain what our history was and some of the factors in the e-filing system that we have here in Orange County. Although this discussion is about e-filing, for us the motive of e-filing was really to get to an all-electronic court record. And e-filing is just the means to get the documents into the e-filing system and the data into our case management system, so that we're all electronic from filing all the way through to the decisions of the judges and keeping the record. As was noted, we started with e-delivery basically by email with our complex cases, which were the really large cases, lots of parties, lots of documents. We then evolved to what we call a true e-filing system, where the documents and the information are coming in through a portal directly into our case management system and our document management system. We piloted it first with the complex cases, replacing e-delivery, and then we moved on and offered it in other case types, starting with public or personal injury cases and then moving on to contract cases. But what we found was if it was all voluntary, we only got about 25% compliance from the attorneys. And the other attorneys kept sending us the paper, delivering the paper to the courthouse. So we sort of said, well, if this is such a great deal and they liked the federal system that they were using, why weren't they using it more than 25% of the time? And honestly, what the lawyers told us was, make us do it. So we went to the legislature in California and got a law passed saying that we could mandate e-filing in the case types if we met certain criteria, and since we wrote the bill, we met those criteria, and proceeded to make it mandatory in civil, probate, and mental health cases starting in January of 2013. The only categorical exception to e-filing is self-represented litigants. There is also a clause you can come and apply to be exempt from e-filing, but that's not a very common thing, and we don't have very many of those. As was noted, we're filing almost 1 million documents a year now through our e-filing system just in civil, probate, and mental health cases, obviously mostly civil cases. We'll be going live with e-filing for our family law matters and our juvenile matters probably sometime in the late summer. And we also have systems where we're exchanging data and documents with the public defender. So we'll be almost completely electronic in terms of documents coming in towards the end of the year probably. The approach that we took was slightly different than the approach that the federal courts took with their system. We decided that we would build a portal at the court where the documents and the data comes in, and then we would have what we call e-filing service providers be the intermediary between us and the lawyers or the filers. And basically, the idea there was that the e-filing service providers would be the ones servicing the law firms and the other filers, and the court would not have to worry about that. We would just worry about the documents and the information when it came in. Currently, we have 14 EFSPs certified. We have to certify them to make sure that they comply with our data and other requirements electronically. That takes a period of time. I think it typically was about 4 to 6 months for each EFSP to become certified. But once they're certified, then we accept documents from them routinely. When a filer who is not already involved in e-filing wants to file a document, they can go to our website. It lists all the EFSPs. They decide which EFSP they're going to use. That's not our call. And we did that on purpose. There's a variety of price points and structures with the different EFSPs. Some of them specialize in certain case types. For example, one of them does a greater proportion of probate cases. Another one handles a lot of unlawful detainer cases for the defendants. And another one does a lot of small claims filings. And then there are a couple that are working on the civil cases primarily. And as I said, we did that on purpose because we wanted the EFSPs to be working with the attorneys to provide the kind of services they needed and work with them about ancillary services, which the court could not become engaged in. And by having these EFSPs, we kind of allowed that link between the filers and the court to develop as needs for the filers because we already had certified them for the documents that are coming into the court. What we're basically getting through the portal from the EFSPs is the documents themselves and data about the documents, who's filing it, what kind of document it is, how they're going to pay the fee, that sort of thing, and have set this up so when our clerk reviews the document and basically clicks on the button that says file, the information about the document automatically feeds our case management system, and the document automatically goes into the document management system, and we don't have to do any data entry and we don't have to do any scanning. So that's the huge benefit to us, and I'll talk about that in a minute. That's a little different from the federal system. In the federal system, the documents go in automatically, and then later the lawyers might discover that the court has looked at the document and has a problem with the filing in some respect and has rejected it or dealing with issues like the wrong case number or something like that. But we review them when they come in. Because different documents have different preferences, we have a hierarchy and queues so that the more important documents that are related, for example, to a motion hearing that's tomorrow, will get seen first and then advanced up into our system right away, whereas something that's not as important, it might take a little longer to get reviewed. We also automatically accept certain kinds of documents that really don't need any review. There's no fee. Proofs of service, for example, they'll come right into our system, and based on the document type, would then be pushed right into the case management system and the document management system. We do not charge a fee for the filing of the document for the court. The EFSPs work out with the lawyers what their fee is to use the EFSP process to file the documents, which again is different from the federal system. And we don't have any requirement for courtesy copies in our court, except in limine motions when your trials get started, which is a pretty small set of the documents that we're actually doing. Everything else, internally, our reliance is on the documents that come through the e-filing system. I'll talk a little bit about the benefits. The big benefit to the court is that we don't have to worry about paper anymore. I literally have no case files and no file room. The only ones I have left are some juvenile and a little bit of old family law. Everything else is electronic. We have the fun thing to show people for the touch it and see it kind of thing is we used to have 17 filing windows in our main courthouse where people would come in and file their documents. I now have 2 windows open instead of 17. There's no documents moving around. I don't have people who are pulling files and putting documents in it, new documents, or pulling files and taking them up to a courtroom and then bringing them back after a hearing. We don't have any of that. Everything is electronic. The judges are looking at the files electronically, and that saves a lot of time and money from the court perspective. And finally, from our court perspective, once the record is electronic, lots of people can look at it simultaneously. There's no issue about, oh, that's checked out to a judge or checked out to a research attorney. You can't look at the file. As many people as want to can look at the documents at the same time on a file, and that really helps with our process. Main benefits to the lawyers in the system. They don't have to travel down to the courthouse or send somebody down to the courthouse with documents or pay to deliver documents. We do have a little provision in our e-filing window that says if you got any special handling features about this document, put it in that little box, and then our clerks will look at it when it comes in. So if it has to go to a particular judge, or if there's an urgency issues or something like that, there's a way to communicate that to the court so that we take care of that. The other benefit that we have for the lawyers is we allow documents to be filed 24/7, basically. What's interesting is that doesn't mean everybody waits till 10:30, 11 o'clock at night to file. We've looked at the patterns of filing, and people still file mostly between 3 and 4 or 3 and 5 when the court's closing. There's a little tiny bump at 11, 11:30. And in talking to the lawyers, they say basically, we like to go home the same time all of you like to go home. So we like to get our work done by 5, and we'll get our documents filed. But we appreciate the ability to file later in the day if we need something, need a signature, need somebody to document to be reviewed or something like that. So we do accept them 24/7. Also, you can keep track in our system of when the document was filed. We know exactly when it hit the EFSP, we know when the EFSP sent it to the court, and we know when the court filed it. So there's much more documentation, and you're able to track where your document is in the process. And I've never heard a lawyer since this got started who said, oh no, I don't like this, we want to go back to paper. They're all fine with this, and my favorite thing that they say, when is LA going to get this system? And I tell them, well, we gave them our CIO, Snorri, so they'll get there pretty soon, as fast as Snorri can get it running. Okay, what about process servers? So we e-file documents that are coming to the court. We don't worry about how documents get exchanged between the lawyers, so that's unchanged in terms of our perspective of e-filing. And also the first paper needs to get served on the parties, the initiating document, because there's no way to e-serve that. But our statute says that if you e-file a document, that's consent to e-service of documents. And okay, so we mandate e-filing, which means everybody can accept or must accept e-service. But we're not requiring that between the attorneys. We let that work that out between themselves. And in fact, we're not actually always e-serving our documents. We're still getting our system set up to do that, and I think it's going to be pretty much complete in the next month or so. Finally, I think that our model for EFSPs is, in a sense, the same model all of you have had with your attorneys in the past. It's just now it's electronic delivery of documents, not physical delivery of documents. But attorneys still need their hand-holding. You know that. You're better at that than we are. That's why we chose the model of having EFSPs, and it seems to be working very well here. So that's a very fast run-through of what our process was here in Orange County, and I'm happy to answer questions when we get to that part later on.
Well, thank you, Alan. Great insight from one of the pioneers, as I mentioned early on, in e-filing here in California. One of the things that Alan alluded to was being able to file until midnight. The Orange County Superior Court has that ability. And in my previous life as director of training, myself and my staff would go out and tell secretaries that during the training. And what we heard was, don't tell that to the attorneys. Don't tell them. Don't tell them. So it's interesting to see that the attorneys that Alan have spoken with are saying the same thing as the secretaries. We don't want to be filing till midnight, but it's nice to have that out if we can. Yeah. Now, Alan mentioned a couple things I just want to point out in case you didn't catch it, about the courtesy copies. Out here in California, that's something that as a court runner I did very often. That's still happening a lot today. But there's a benefit. No courtesy copies in this court because it's all electronic. That's less printing for you and perhaps saving you all a trip trying to avoid that CHP or whatever highway patrol you have in your state to try to get down to the court to deliver that copy. Another thing I remember as a court runner, trying to find those missing files or documents, that is no longer a problem with e-filing. So it saves you all time and your customers time. You don't have to try to find those things that you used to, or maybe still do, spend a lot of time trying to find. Now, Alan mentioned in a conversation we had previously that his court files about 900,000 to 1 million documents a year, and he mentioned in his talk that storage is not in paper. But I'm curious, where exactly do you store those things, Alan? Are they on big servers somewhere, or what?
Yeah, we have a data center where we store all the documents. We've actually been scanning documents. We probably have 15 or 20 million documents from all different case types. They're all at a data center. And then we access them through our data lines. But I keep them in the United States. They're not anywhere else.
That's good to hear. Thank you.
Yeah, and not up in the cloud for now.
Not in the cloud? No, they're in the cloud. That's right.
Not in the cloud right now.
Not in the cloud. Depending on what your definition of the cloud is. As I remember telling my mom, no, Mom, it's not up there in a big cloud. They're actually servers on the ground in some air-conditioned building. But in any case, this is a good segue to our next presenter, Casey, because I was going to ask Casey, I'm curious about the Texas courts. What do they do about storage? And after you address that question, sir, go ahead and regale us with your remarks of the day.
Sure. Thank you, Mark, and thank you, everybody, for joining us for this. So we're a lot like California in that Texas is very decentralized. The documents are actually stored at the court, and so, like California, each county has their own IT department and their own case management system, and so each county stores their documents. Most of them do it electronically these days, and they just use the servers that they have in the counties. I haven't heard of any counties in Texas going to the cloud either. They all do it in-house. Now, the way we're set up here in Texas is just like California. There aren't very many commonalities between our two states. I know that politically our legislature doesn't like the way California's run, and our people that's the wrong way to do it, but we run e-filing the exact same way. We have electronic filing service providers just like they do in California. The big difference between the two states is that here in Texas, our e-filing manager, the thing that the clerks use to accept and return documents, is statewide. So where in California Alan has one, and then Snorri can put one in LA. Here in Texas, all the counties use the same tool. Right now, we've got about 22,000, 23,000 documents flowing through our system each day, every day. We see the same thing of where documents usually peak out at about 4 to 6 p.m. and then they dive down. Coincidentally enough, when we had e-filing become mandatory in 2014, our Supreme Court did an e-filing mandate where the most populous counties had to go first, and so you think Dallas, Fort Worth, Austin, San Antonio, Houston, the counties that those cities are in became mandatory e-filing for civil. Same thing, attorneys only, not required for self-represented litigants, although we do have 2 EFSPs that cater to those groups, but they're encouraged but not required. With that mandate, we see the counties pulling in more and more documents. We do integrate with case management systems. The nice thing about our EFM, there are APIs so that EFSPs can filter into that system, and then our system can then filter down to any case management system that's out in the field. In Texas, there's probably about 4 case management systems that we do. Like I said, civil e-filing is mandatory for all of our counties that have more than 50,000 people in them, which is roughly half the state. The rest of them are coming online and will be mandatory by the middle of 2016. With process servers in particular, there's some very interesting things going on. Alan mentioned the use of electronic filing service providers. We do the same thing. They handle the frontline support. There are no courtesy copies, so everything comes in electronic. On eService, we have the same thing. The initial document, the citation and the copy of the petitions and those kinds of things have to be done in the physical world and can't be done electronically by the way we have things set up. But then subsequent filings, I'm filing a motion on an existing case. By doing that electronically, you're subscribing the other party to do that. And so all of that happens electronically. But even though we're not allowed to do electronic service on those initial documents, we are seeing some innovations come about that impact the process server world. And it's very interesting to watch because county by county has a different reaction to it. And that is with electronic citations. So in Texas, the only thing the clerk is required to do is to produce the citation. That's it. It's up to the attorney to attach a copy of the petition and to get it served however the attorney wants to serve it. And so now what we have is we've got some process servers that will work with attorneys, and when the attorney files a document, they'll go in and say, hey, please prepare the citation, and then they can ask the clerk to do that and pay for that. And then, by the way, please send the citation to the following either process server firm or process server, and the clerk will generate that PDF document and send a copy of the file stamp petition to the process server along with the citation. And the process server can do their thing and then file the return of service electronically as well. And so that electronic citation stuff is interesting in that it's getting people to wrap their heads around, and clerks to wrap their heads around the fact that you don't need to run 4 copies of a petition to staple copies of citations to. You can send it out electronically and then have a process server generate and assemble that on behalf of the attorney as a value add and get the clerks out of printing documents, which is very interesting. Then on the back side, one of the main rules that we did with electronic signature is say that you can electronically sign documents, much like I think what they've got in California. You use a username and password to get onto our e-filing system, and our rules say that your username and password is in effect your signature, and so all you really need to do is /s/ in the name to sign something electronically, and that includes returns of service. And so what that allows some of our service providers to do, and we've got a couple of them that do niche markets with the process servers, is they do interesting things like one thing we've seen is a phone app to where if you're with this one group they have a service to where a process server can join in with them, and whenever process needs to be served on that original document, that person can look on their iPhone and get a copy of the document. If they have a mobile printer in their car, they can print out the citation electronically, print out the petition, staple together, serve it, and then hit a button on their phone. And when they do that, it takes the date, the time, and the GPS coordinates that they're standing at and prepares the electronic return of service and then files it with the court on their behalf. And that usually takes between a minute to a minute and a half for that to go through. Of course, because they're a service provider, it charges a fee for that. But in the grand scheme of things, you know, if it, and I'm not sure, there's a lot of people not from Austin, but our traffic here is horrible, second only to what Snorri sees in LA County. But if you can save people the time from having to drive downtown, and instead, if you need to go serve 10 people today, you print it out in your car, you serve them, you hit the button, and you're on to the next one. And that way you can cycle through people to serve very quickly. And so kind of to build on what Alan was saying, you know, one of the great benefits that I've seen in this electronic filing service provider model, and I'm sure they're going to start seeing this in California if they haven't already, is the level of innovation that's going on. A lot of the things that these service providers are putting together, there is no way that the government can ever fund any of this or would, because, you know, things like I said, we're doing a phone app so that you can serve people. We have another service provider that does the service. We got rid of our fax filing rules. You can't fax file to the court. Well, one of the service providers said, hey, you can fax it to me and I'll turn it into a searchable PDF and file it for you for $1. And so we get a lot of competition, a lot of different levels of support. I really enjoy the fact that as an IT director, I don't have to run a call center just to do attorney support, because by trade I'm an IT guy, not an attorney, and I don't want to do any attorney work any more than they want to do IT work. So with that, I'll turn it back to you, Mark. Those are my short remarks, and again, like Alan, I'm happy to answer any questions.
Well, excuse me. Thank you, Casey. Very enlightening, and I love the Texas perspective. And yeah, I think you might be number 2 in the traffic world, and I think LA area is number 1. And yeah, I have the privilege of living in the Bay Area, and traffic is quite the bugaboo. So Casey mentioned this several times. I'm sure you all picked up on it, and it's a theme that you're going to see throughout the panel's presentation today. And traffic isn't quite the issue when you have e-filing. You don't have to deal with that. Certainly from the attorney and their staff side, that's great, but from my side, from a processor or court runner side, hey, I don't mind not having to deal with that when I don't have to deal with that, if you get my drift. Another benefit Casey pointed out, signatures. In California, at least in a couple of courts out here, Orange County and San Diego, the attorneys and their staff don't even have to sign the documents. They can upload them directly from their computer, not signed, and then file them. So that saves scanning and time at the law office. That's something, of course, that they can take advantage of. Casey, you mentioned this kind of tiered approach to bringing courts online in Texas, and I'm curious. You know, out here in California, we always like to say, oh, we have 58 counties and we're really big. How many counties are there in Texas, and do you know how many are left to be mandated?
Yeah, we've got about 150 that need to be mandated. So the next 2 rungs are, I think, 70 some odd counties in the last. Well, no. Let me think about that. It's more like 180. I think the next rung is about 70, and then we have another 120 some odd in the last rung. And our counties, we run the gamut. We have a total of 254 counties. The largest one has 4 million people in it, and that's Harris County, which is Houston. And then the small one, if you can imagine Texas, where the Panhandle is, there's a little county right in the square of the square that has 67 people in it, more cows than there are people, and so we've got everything in between. So we implement in really big, high volume, and we really implement in the ones that only have 2 filings a month.
Wow, thank you. I wonder if those cows go and try to file. Who knows?
Yeah, if they can find the courthouse.
That's right. Well, Well, thank you. Thank you very much, Casey. Much appreciated to get that insight from Texas. All right, next up on our list is Jim McMillan. Jim, why don't you tell us what's going on from your world from the great state of Virginia, sir?
Sure, sure. Actually, now I'm a member of the international division at the National Center for State Courts. And so I get to go around and go to interesting places like Rwanda, where I was earlier this month. So I'm going to talk a little bit about international, what's going on there, a little bit about federal courts, and then some ideas that we've been working on. First of all, a lot of the issues revolving around e-filing and noticing has to do with whether or not a person is known or verified in the electronic world. And so we'll travel back in time to the country of Austria, back in 1989, who was the first court system, the first judiciary to actually do e-filing with dial-up modems and all those kinds of good things. But what they did was they set up a centralized email system that all the lawyers, all the filers, majority filers became members of. So this was really actually a very good idea, and we just received a report from their manager through a friend of mine in Abu Dhabi that says that they're doing well and that they're serving notice that way using their email system, because they know when you're filing with or sending notice to another attorney that that's how you do it. So we're taking that idea and taking it to Nigeria in Africa. And we did a contract with Microsoft. Now that the cloud technology is there, that we are eventually going to put 70,000 lawyers in Nigeria onto a verified single court-controlled email service that, of course, connects to their mobile phone with text and SMS, so that we can send notice that way, because they have massive problems with court case delay because of lack of notice or lack of service. So we're going to overcome that with this verified email system. And just to let everyone know, there is another step beyond this, and that's where you go to Singapore and they have the LawNet system. And in Singapore, if you're an attorney, you're required to be a member of LawNet. And LawNet is a single network built for the legal community. So I think over time we will all be building toward LawNet, although it might be the 21st century project. And last, just so you know, you can also do these notices and things very simply. In our Serbia project, we actually have little cell modem USB dongles that we plug into laptops, and we send out reminders and to the SMS using text with an Excel spreadsheet. So it can be done very easily and very inexpensively, at least in terms of a very low-end reminder system. So here in the United States, I just wanted to do a plug for my blog, the Court Technology Bulletin. And the easiest thing to do is to just go to Google and type in Court Technology Bulletin, and you'll get to see this article that we did, where we picked up from the U.S. Federal Court Bankruptcy Courts. And they have a national bankruptcy noticing center because, of course, the creditors wanted to be immediately notified when somebody filed a bankruptcy case. So they have now connected that to an electronic notice capability for the creditors in particular. So that is reported to be saving up to 4 days of time, which for a creditor is an important thing. And as part of the creditor world, one of the things that we're starting to see is that the registered agents like CT Corporation are considering to becoming EFSPs, and I know they've talked to Casey about this in the past, so that they can receive notice for their customers. So we tried to work that into our Michigan e-filing project. There's a lot of politics that didn't allow that to move forward very quickly, but also as part of that, we didn't forget about the process service industry. and the noticing industry, but because we know that as Casey and as Alan talked about earlier, that you still don't get away from the need for direct paper, physical access to people that are not registered. They're not part of the club. So we wanted to make sure that the folks would have access through eFiling, just as Casey was talking about, to the service providers. So we were going to try to build a store, basically a process server store as part of the electronic service system, so that you could be tied into the FSPs, they could make links to you, and you could sell your wares that way, sell your services. So we definitely wanted to do that. So just to wrap this up, in the article that we did, I got one more after this, sorry, I lied. One more. We also did an article, and this actually ties into our Nigeria project, but other places, is that you're still going to generate a document, something that may have to be printed on paper. And so in the past, courts have always relied on the type of paper that it's printed on, maybe a fancy header that's with the court's name and things, and of course the good old rubber stamp, which of course is a pretty low bar for document verification these days. So one of the things that we've been exploring and that we'll do in Nigeria is that we're going to generate a QR code, which is those square little codes that you can use your mobile phone to take a picture of, and it'll take you to a website or bring you up a particular coupon or something like that. Well, we're going to have it so that you can link back to the system, and we at first we're just going to give you the verification, kind of the details, the information about the document that was filed. It was filed in this court on this date by this person, that sort of thing, and then later on we'll hopefully have a link so you can actually display the document. And we learned about that. That's a big need out there in the world, because we have people falsifying court documents, and so this is a way to do that. And of course, with the QR code, it would be very handy, as you can imagine, to do return of service with an app. And finally, last, we have had a few instances. I was talking to my fellow blogger here at the center, Bill Raftery, who follows the Gavel to Gavel blog. He builds that, and he follows all the legislation that's going on in the United States related to courts. And we were talking about social media service and Facebook service, that there's been a few instances, particularly like in domestic cases, where the judge has just gotten so frustrated in trying to contact a person to give them service, to give them notice of a particularly domestic matter, that they allowed the parties, one of the parties, to use their Facebook account to give them that notice. It's happened in Australia, and I think one other country at least. So it's there, and it's another area where potentially you could see the process service industry providing a service to do that research and to do that work. So I think there's still some good opportunities, some good places to do innovative work. And Mark, I have to unfortunately drop off because I promised to speak to a class at Columbia University at 3:30. So since things got a little delayed, I'm unfortunately going to have to say goodbye after this. But if there's any quick questions, we can do that before I drop.
Well, thank you, Jim, and yep, I understand. This gentleman is in demand, so if any questions come through for you, maybe I'll forward them to you by email, sir.
Send me an email. That'll be great.
Yeah. Thank you much for joining. See you later,
Thanks,
Jim.
everyone. I enjoyed it. Great to see all my buddies. Okay. Bye-bye.
All right. Well, as Jim exits the panel, I wanted to mention that service via social media that he brought up, something that I followed quite extensively, and I've done some presentations about that. And I want to point out that it is not codified. It is case law in the United States. Although I've seen other states, there's a case in Minnesota that comes to mind. But essentially, what it comes down to is the courts, they don't want defendants to get off the hook when they avoid service. So they're starting to realize there might be a different approach, a unique approach to getting them notice. And again, it's not codified, and there's some steps that you have to go through. But it's an interesting progression, I think. You know, we've talked in California about maybe this becomes a requirement for publication. Instead of doing the typical publication in the newspaper, perhaps you publish via social media as well. Who knows where that'll go? And I think that's a good segue to our next panel member, who has served thousands and thousands of papers in his life. So let's turn it over to Mr. Nill, and he can fill us in from his perspective. David?
Thanks, Mark. So obviously I'm the industry representative giving the process servers perspective of this conference, and you know, feel very blessed and you know, thankful to be on this call. I think what ServeNow is doing and what this conference is all about is just tremendously beneficial to all of us as we go through this. So what I'm going to do is kind of pose to those on the webinar. Adam asked a question at the beginning of the conference where he said that in their office they have a question, and that is education bad? And obviously the answer to is education bad, you would hope, would be never. And I wanted to ask everybody listening in, is technology bad? I believe the answer is no, but how comfortable someone may feel may change that answer to yes. It's only bad if someone feels overwhelmed, incapable of measuring up, or that you don't feel like you have any choices. And I know in that situation, technology can be very scary. The way to address that is you need to act. You need to become part of the process and part of the future. Change is not easy. Making the leap from offering traditional services to also offering electronic services is not easy. And the key to making this a reality is for you and your company to buy in yourself, and then getting all the stakeholders in the system to buy into that reality that technology is not a bad thing and that you can use it for your benefit. You must also understand that a lot of participants in the legal process are very apprehensive, and they're looking to you, and the value you bring to them is to be able to convey that confidence on how to use technology to their advantage, and that you would see the benefits for the customers and for your own self in making that transition and being part of that process. So just to kind of go into a couple different points, you know, the first question that comes to mind is, why did I make this leap? And there was really two main reasons. First, I saw the writing on the wall. Technology brings efficiencies to everyone involved in the process. Courts, litigants, your law firms, everybody, you have the advantage there of bringing that value that technology brings to the process. Second is technology is not going away. In fact, it's becoming more and more in everyone's daily lives. And that will continue at even a faster pace as time goes on. So if it's not going away, you might as well use it to its greatest efficiencies and greatest benefits to everyone involved. What pain points I experienced when I was making the transition, you know, one of the greatest pain points, quite frankly, was losing customers and long-term partners, other process servers, that didn't want to work with me in this way. They felt intimidated, they felt like, was it legal? And they were very concerned about that. And because of that, that caused them to, you know, shy away or to push back. But like I've shared many times, one of the greatest satisfactions is when those customers come back and realize that they're your biggest fans and they're your biggest supporters. So that's a big advantage to you know, or big satisfaction to what happens when customers see those advantages to it. Next was figuring out how to handle both the old way of doing things as well as the electronic way. You're essentially going to be running two operations for a time being. And I'm sure Alan, who's done the transition, or Casey in Texas, who's done the transition, realize that when you're trying to run it both ways, it's very, very difficult. And that's a great pain point that you guys just have to be prepared for. Lastly, the expense of transitioning to technology is never going to be cheap. But it's well worth it in the long run, and you just got to do it for the sake of where your business is going to grow to. So as I look at my notes, excuse me. The third thing that I wanted to talk about a little bit is that what you need to do when you're making this transition. And I label it as you need to be persistent, dedicated to making the transition. As you would expect, the customers that we have, the partners, did not respond well at first to us making this change. And I made this change 10 years ago, and it was extremely painful then. Less painful now because it's becoming more and more of a reality every day. But the fear of the new and unknown procedures and requirements are daunting to most people. Even some customers who are very tech savvy push back because no one likes change or having to learn a new way of doing things when they're forced. But it's to their benefit, and you need to be persistent about that. The next thing is it takes a lot of patience and understanding that most of all, it's a commitment not to reverse course. You can't go back to your old and familiar ways when it gets tough, because it will get tough. And you just got to be persistent and diligent on pushing through, and at some point you'll see a light in the tunnel. So being persistent is extremely, extremely important. What do you need to do as a attorney service, a traditional attorney service, to make the transition? And I would give my suggestion of the first steps that you would need to do. The first thing of what I did was immerse myself in technology. Everything I did, from online banking to buying products online, understanding user interfaces and flows, understanding e-commerce, understanding Adobe, understanding how documents work, what's text searchable, what's not. Get comfortable with technology, because the value that you'll bring to your customer is your knowledge. You're the expert. Alan said it earlier, and Casey touched on it. The value that you bring is that customer support. The training and the support that you give to the customers is where you fit into the process and where you can continue to fit. But you need to still make that connection to the courts and to the technology world of how you move legal documents. You need to become an expert on e-filing and e-service rules. I find it interesting that all of us who've been in the process serving and court filing business for 10 or 20 years have been reading court rules and CCP, rules of court and procedure rules, codes of civil procedures for 20 plus years. And yet when it comes to e-service and e-filing, we're all of a sudden nervous and scared, like, oh, we don't know what that rule means or how we're going to, make it a reality. And the fact of the matter is, it's no different than any other rule that we've been complying with for years. It's just you've got to become an expert at those rules and then figure out who you can partner with, whether it's becoming a direct EFSP to the court, partnering with another company that can provide you that, hiring technology people, or partnering. There's an old saying in the technology world, you either buy it or build it, but there's always a path to becoming part of the system, and you just need to figure out how you stay relevant and how you stay in this in the process. Lastly, and it's really the same thing that I've been kind of hammering on since the beginning, you need to be committed to the transition. It's going to be a tough road. There will be many times that you want to give up and go back to just the way you used to do it, especially when your customers aren't buying into the new way you're operating. But I can tell you by my experience that if you offer them value and you fill the need, they will come back. I have many customers leave because they wanted to continue to do it the same way they always did it before. But the greatest satisfaction is when they came back and they become our biggest advocates. So, you know, like I said, I think the main thing is to stay relevant, to partner with everybody that you can, and not get intimidated by technology. It's just another tool, no different than a hammer and a nail. It just seems a little bit more daunting to start with. So with that, I'll turn it back over to Mark and be available for any questions.
Thank you, David, for that perspective, one that's near and dear to my heart, as all of you recall from my intro. Been doing this a long time too, and there's still a lot of opportunities out there, even though times they are a-changing, as they say. You know, David alluded to training, and I want to mention that again from our perspective. And one of the things that we found when we started training our customers on our interface is we ended up getting a foot in the door that we wouldn't get otherwise. They're sometimes loath to take a call from a salesperson, but they are very interested in getting trained on the interface, trained on Acrobat, for example, if they have to bookmark and do other things that they don't understand how to do. And so we found when we approached them from a training perspective, hey, we'll come in and train, and we'll show you what you need to know. We would also sell. And that's certainly one of the big benefits that I'd like you all to consider. When you do a training, it gives you an opportunity that you might not have had otherwise, and gives you the opportunity to promote other products. David, you mentioned when we had talked before about getting law firms and litigants to buy in. And I'm curious if you could take just a minute and explain, you know, how did you do that? Did you do meetings, trainings, cool collateral? How did you do that?
Yeah, I think the first thing that you have to do is you have to buy in yourself. I think that there's no way that someone's going to buy into a new way unless you're committed and you understand about what the value is to the end user. So it is a little bit through collateral, but you know that marketing material is important. But I think it's having dialogue and it's having conversation and it's really understanding where the customer is going to benefit. I find it interesting a lot of times when people are talking about technology and you have little hiccups along the way, they think, oh my God, this doesn't work, because they're looking for a way. And I mentioned it a little earlier, is the answer is technology good? And at the start it's good as long as it's not something that I'm uncomfortable with or I'm afraid of it. But once you understand it, you can then pass on where they can benefit, and realizing to submit a filing literally within minutes and have a conformed copy back in your email inbox is faster than printing it out, you know, putting it up at the front, having someone pick it up, drive it to the court, come back, drive it back to the law firm, and drop it off in the basket is taking literally days, when in an e-filing world, sometimes it's as fast as hours. And so I think it's the buying in starts with you buying in yourself and really understanding, okay, what is the value that this is bringing to my customer? And you know, that's what I would share with you.
Thank you, sir. Much appreciated. All right, let's turn it over to Snorri Ogata, and he will bring us up to speed on what's going on in the LA world and beyond, perhaps. Snorri, it's all yours, sir.
Okay, thanks. So I'll address you by talking a little bit about things going on from a court technologist perspective. So what's going on in Los Angeles and California is really, you know, a microcosm of what's going on nationally as well. So there's lots of movement in the court space towards new case management systems. I think part of it is no doubt driven by the ROI that's available from e-filing. So in California, 50% of the 58 counties that exist here have entered into contracts to replace their case management systems. In California, we've pretty much consolidated around 4 vendors, but that should be relatively transparent to all of you. But as the courts go live with their new case management systems, they come under enormous pressure, mostly internally, to stand up the e-filing capabilities, right away, as that was a big reason for the sale of, or the justification for spending the money to go do that. So you're seeing a heightened pickup of activity in California around e-filing. So what's interesting then about this is that as the trial courts start to expand and explore e-filing, then at an individual level, then the state starts to take notice and tries to figure out what role they should play relative to this. So as you heard earlier, Allen and Orange County stood up a completely local e-filing solution that benefited the county of Orange and the people that interact with that court. In the last month or two, a couple of smaller counties north of Orange have gone live with e-filing, and it's anticipated that easily all of these 29 counties that have signed up for their new CMS systems will be trying to stand up voluntary e-filing solutions shortly after their go live events, which will happen over the next couple of years. So the state is getting ready to launch its sort of exploration on what are the options around e-filing, and so there are really sort of 3 options that will probably play out one of these 3. There's a lot of interest in the success that Casey has had out there in Texas. It's a nice clean model from a lawyer perspective. Wherever you are in the state, you go through one e-filing gateway to the court. You may go through a number of EFSPs, but that has certainly a lot of appeal. It ensures that there's uniformity in terms of access, which is a key selling point. For the state. The other end of the continuum, though, is local control. So the way that the court system is set up in California, Allen is the CEO of the court in Orange, has full authority to do whatever he wants to with the money that's been appropriated to him. And CEOs don't like to give up control because they turn that control into good customer service to the public they serve. So it creates sort of an interesting tension that way. So that's clearly going to be option 2, right? Let each of the 58 courts go their own route, but that has some inherent drawbacks to it. And then the third alternative that might emerge out is this sort of court consortia idea, and that may be that the courts that have standardized around vendor A may join together and create a solution so that the EFSPs that work with that particular vendor population can service any of those courts. It could be geography based, right? So it could be that the Southern California courts get together and do this. So I don't know how that'll actually play out in the long run, but it's definitely something that's been going to be examined. Part of the examination of it is, twofold. Well, it's actually onefold, right? It's all about the money. Follow the money. So the case management vendors have realized that, after they sell the courts these new case management systems for millions of dollars, they're not happy just making hundreds of thousands of dollars from the court for licensing fees when they could be making a dollar or 2 or 3 or 4 off of every transaction that's flying through the e-filing universe. So they're all selling as part of their new case management system offering e-filing capabilities, and they're including it in the price to the court. And so that's creating this sort of interesting pressure, and the CEOs, in the court are sort of realizing that these vendors, by definition, since they control that last mile into the court case management system, have virtual monopoly, and that makes them a little bit uneasy. So, Allen is being a great champion right now on behalf of the state of trying to drive those costs down should those vendors be put into a position where they get to control that last mile. On the flip side to it, each of these 50 or 29 courts that are going to new case management systems are spending an awful lot of money to replace these old systems with the new systems, and they are looking sometimes for funding streams because California has been in some tough budget times these last 6 or 7 years. So I think because of the money, there's sort of this interesting dynamic that's going on in the e-filing space, as everybody's looking at how to monetize the work that's that's going on there. So interestingly, I think what's emerged out of all of this is that the biggest threat to the attorney service and process serving world isn't really the courts, it's the case management vendors, because I think the courts really like and value the eFSP model, right? And so as Alan said, a trial court wrote the law in California that enabled e-filing, and a key provision in that law was that we had to have multiple e-filing service providers. We, at a trial court level, fully appreciate the value that you bring to the table in terms of marketing and training and providing support and offering differentiated services. Even the one that Casey mentioned is funny to me, right? So there still is a community of lawyers out there that like to do everything by fax. So great, an eFSP can insert themselves in the middle of that transaction to enable the activity that happens. So from a pure trial court perspective, we completely value the role that the eFSP plays in there. We fought hard to preserve it when we were in Orange, and we'll continue to fight to preserve that role going forward, because there is a lot of value having it be somebody outside of the court. But my sort of cautionary tale for all of you out there is if you become an eFSP in California, right, for one of those things at a local level, consortium level, or state level, if it's one of the local level sort of alternatives or consortium level alternatives, we're all going to be in a bunch of trouble if you all want to go and do e-filing in Los Angeles and Orange counties, because that's where all the transaction volume is, but nobody wants to do it in Alpine County, because then we're going to end up with access issues, and the Chief Justice is going to come down on us and say we have to come in with statewide solutions. So take the approach as an eFSP that you're going to be working with the state, even if you're going in under the auspices of a single county. I think the second thing is, Alan alluded to the fact that it took like 6 months to onboard an e-filing service provider. The technology in this is a lot harder than you think. I mean, I sat at the table with probably a dozen or so vendors in Orange who all came to me and said, I've got this great IT guy, and we're going to be able to stand the system up in 3 weeks. And 6 months later, we're having a meeting with them where they're realizing, gosh, I didn't know how hard this was going to be. So I think there's some, just take a reality check, figure out some strategies, to deal with that, and then maybe the opportunity is to figure out and form those partnerships with those CMS vendors. That might be a good interim step as the state figures out what it's going to do at the local consortia or statewide level. But you'll absolutely see a tremendous push for e-filing here in the next 2 months to 2 years across the entire state, because every court that's bought a new case management system has an expectation in their community that e-filing will be part of that answer very quickly. So back to you, Mark.
Thank you, Snorri. Much appreciated. Snorri mentioned an opportunity, which I think I've mentioned that word several times throughout the panel today. Partnering with a CMS provider. Perhaps that's an opportunity. I want to point out that perhaps the opportunity is to point out your value as opposed to their value. Oftentimes, if not all the time, these providers, they don't have the attorney service experience. They don't have the boots on the ground, as I like to say. They don't have that real, tangible knowledge that you all have of the courts and how they work. They're mostly tech companies. So keep that in mind. Certainly, there may be an opportunity to partner. But there's other opportunities there as well. And David, you wanted me to ask you about that point Snorri made, so expand on that, sir.
Yeah, just the point as far as that doing it is not the easiest thing in the world, and being the eFSP and the point Snorri made about there's a lot that goes into it in the technology, doing the whole end-to-end that he talks about, but the role that each person or each company can play, you just have to be in the game. You may be playing, it may be the eFSP way, but it's being part of the process. You may be partnering, like I had mentioned earlier, as far as whether or not you buy or you build technology, I think when you're talking about what Snorri was mentioning as far as building the technology yourself, that may be difficult, but there are going to be opportunities to partner with other companies to do technology. And that's where you have to look for those opportunities and figure out where you can fill the gap to continue to provide the value to your customer.
Thank you, David. That was a great follow-up. And for those of you who didn't catch on, yeah, we have the ability to text out of sight. So love the use of technology in this respect for sure. Now I see that Trent is on, which means that's our cue that we're getting close to the end of our time, and Trent may have some questions for the panel, sir. So shoot.
Well, we're getting close to time. We have about 5 minutes, so if anyone has questions out there for this panel, now is your time. We don't have a lot in there right now, but there is one question for or request from Alan and Snorri, or for Alan and Snorri, which I'm sure you can just fix with a quick keystroke. The question is can you please update your court policy to include the $60 ex parte fee? So, right after this.
Snorri, that wasn't, or Alan, that wasn't for me.
Me neither. Me neither. Obviously, someone's paying attention. I love it.
As soon as we're off, I'll take care of it.
I figured as much. I was going to text you and ask you so you could take care of it right now, but I figured I could wait. No, gentlemen. No other questions have come through, and we definitely filled the time. And amazing panel. I'd like to thank each and every one of you. This content has been wonderful. Mark, thank you for putting all this together. And for those of you out there, I know that the video was a little choppy in some areas, but rest assured that the recording will be very, very clear. So you'll be getting a very clear recording of this as well. Actually got a question from the audience for David Nill. Is Rapid Legal open to affiliate partnerships?
Sure.
Did you see that?
Did I see that?
Did you see that question?
No, I didn't. I said absolutely.
Right.
Well, thank you, Trent, and I'd like to
partners, as do a lot of other companies.
Right.
Yeah. We're all in this together, as I like to say, and I want to echo what Trent said and bring us home and thank the members really of the panel for their time today. As Trent mentioned in his intro, these folks are some of the movers and shakers in the e-filing world, and we were very privileged to have them. If you have any questions down the road, because sometimes those things come in later, feel free to reach out to Trent. He'll forward them to me, and we'll do our best to get them answered. I know the panel can't necessarily hear your applause, but I'm going to give them some of mine and hope you're all doing the same. Thank you all, gentlemen, for your time today. And thank you to ServeNow. You guys are awesome. You host such a great conference, a virtual conference we can all attend from our desks, and that is a beautiful thing about technology. Most importantly, I want to thank you, the audience, for attending and participating today. That's awesome to have folks, over 100 folks as I understand, some of you from Canada, so very cool. I hope you all found it very helpful, and it got that innovation gene going. So have a great rest of your day and enjoy the remainder of your conference, and we'll see you either out on the airwaves or in person, depending. Take care.